Welcome to Probate Weekly. I'm Bill Gross, and we do probateweekly.com every Thursday at a new time, 9 a.m. Pacific time, 12 noon. We also live stream it onto Facebook and LinkedIn, as well as available for recording afterwards on YouTube and various sources on Bill Gross, at Bill Gross Probate on social media. And we talk about topics that are of interest to real estate agents, attorneys, investors looking to build their business in the probate real estate space. ProbateWeekly.com is the program. We have a Facebook group, if you missed and want to continue the conversation, called ProbateWeekly.com, easy to find. If you're getting this on recording and want to go live, you go to ProbateWeekly.com and sign up. All we need is your email address. We'll send you reminders and links to the Zoom so you can jump in and ask questions. You can also see any best on your favorite audio formats and see past episodes on YouTube. I'm really excited today to have an attorney, Elijah Underwood, who is with the Underwood Law Firm. You'll notice the last name matches up there. A little nepotism, perhaps, we'll find out. And in particular, the reason I'm excited to have him is they are the California's premier partition lawyers. I came across them when they opened their office here in LA. They're known throughout the state in the specific area of partition real estate. So we're going to have a chance to talk about that, hopefully, and learn about more what that means. So, Elijah, thank you so much for joining us today.
Hey, Bill, great to be back.
So of all the areas of law to practice in, how did you end up focusing in partition real estate?
Yeah, so it's a longer story, but I'll try to make get to the point here. Basically, I was a partner at a firm. I was doing a bunch of different things, and doing a bunch of different practice areas is kind of like trying to be a decathlete at the Olympics. Maybe you're okay at everything, but you're never great at one thing. And really what I wanted to do was just be excellent at one thing. And around that time, I found myself investing in real estate myself. I bought an apartment building. I was meeting with a lot of real estate developers and investors as clients. And I was really involved with something called the Urban Land Institute, which is an organization devoted to development and improving our urban spaces. I was on the board of a local chapter, and I just saw my life with real estate, just loving real estate and real estate people, and just finding that I clicked really well with real estate people, kind of coming together with the law practice and finding, well, I don't like this piece where I'm doing 30 different things, and some of them I do well and some of them not so well, and I just kind of had this realization one day: what if I could just do something that I really liked all the time and involve myself with real estate more and more, and spend, not just my free time doing real estate exclusively, but also my work life. And it just occurred to me that sounds like a great life, and it sounds like I would really enjoy it. And it was something that I was particularly good at, as opposed to other things I'm not particularly good at. And so I just kind of had this idea for the firm, and it's been going ever since.
It's such a great story for all of us, but whether you're an attorney or a real estate agent, to find an area that I think both you're good at, which means you're going to make more money per hour that you work, you're creating more value for your customers, there's more opportunity, and also you enjoy doing. And I think as real estate agents, some of us go through different phases where we love open houses, we love door knocking, we love cold calling, but then we don't. And you can design a business by finding a niche that operates differently. That's how I got into probate real estate. So let's talk about partition.
Well, think about what your readership or viewership may do, right? So if as a real estate licensee, right, as a real estate salesperson licensee, you can do a lot of things, right? You could sell a single family home in your neighborhood, wherever that may be, in Long Beach or in Encino or wherever it is, right? You can be a local expert, right? But with that real estate license, you could sell Class A office space in downtown LA. You could sell, oil and gas leases, right? You could do commercial leasing on the 3rd Street Promenade in Santa Monica, right? You can do a lot of things with a real estate license, but most people don't. Right. They are, they say, okay, I'm going to specialize in apartment buildings, or I'm going to specialize in, this particular neighborhood in Brentwood or whatever it is. Right. And so that's kind of how I've set up my practice. Is I just say, listen, there's some things that I think we're pretty good at. We just try to do those things that we think we're best at, and everything else we kind of leave to everyone else.
We talked before we started recording about my brother-in-law who focuses in
Right.
industrial property just in Southern California, and how he's tremendously successful. And one thing I've learned now, as I look back at my career, the people who are most successful always had a niche that they both were great at and enjoyed working in, and that combination that you expressed, I think, is critical. So let's talk about specifically partition actions.
Sure.
Maybe again, our average watcher is going to be a real estate agent who's maybe an investor or deals with investors. Talk about the basics of what a real estate partition action looks like.
Sure. So at its most basic, you have two or more people who own real estate, and one of them wants to sell and another one does not. There's a couple main flavors that we commonly see. One is, boyfriend, girlfriend buys a house together, right? Anticipating they're going to get married, but then, before they can cross the finish line, something happens, right? And so then they find themselves owning real estate together, but wanting nothing to do with each other. And, and especially with interest rates being so high recently, with home prices increasing in value so recently, appreciating so recently, it's been kind of, the house becomes this tug of war where one person really wants to say, another one does not, because they want to move on with their life, right? That's one main flavor. Another very common flavor is, brother and sister inherit mom and dad's house in Palos Verdes. And, maybe sister was taking care of mom for the last 7 years, and she's kind of built her life in, Palos Verdes after returning to do that. But now that mom is gone, brother and sister own it, and brother lives in San Francisco. And brother says, hey, listen, I'd love to sell mom's house because that can help me pay off my mortgage, or put one of the kids through college or whatever it is. And for sister, there's some tension because, she kind of has her life in this house, which is now worth, I don't know, $3-4 million, right? As long as it's not, one of those ones falling into the sea. And so it's, there's some tension there, right? There's an issue to work through. And then we also have a third main flavor, which is real estate investors and developers. So we are doing partitions on industrial property, warehouse property here in LA, ag land in Stockton, apartment buildings in, Riverside, right? Multifamily. So, we kind of do all of the above when it comes to real estate, because if it is real estate in California and you're an owner, there's a right to partition.
So again, the three you mentioned are a relationship, boyfriend, girlfriend. In my experience, one's kind of bullying the other, right? They went into it as partners and now they're falling apart. And the one says, no, I'd rather keep it. And you can't force me to sell the property. Well, they probably can if they know the law. And that's why we're interviewing you today. Second being they inherited, which is probably through a probate. It's probably through a probate didn't have proper estate planning, because now you end up with two siblings fighting over the situation. And to add the component, I think in your scenario, we'll get to that. And the third being a developer. So let's go back to the first one, talk about that. As real estate agents, we've all sold property to people who weren't married. We weren't going in. What are you doing? So what does the exit look like? The girlfriend or boyfriend call you and say, hey, I'm in this deal and I went out, and my former love interest, love of my heart, partner for life, soulmate now has become a rat, and can you help extricate me? What's that process look like?
Yeah, so really a partition action, almost, all partition actions have four main parts, right? So you file a lawsuit, and unlike other types of lawsuits where you accuse somebody of wrongdoing, it becomes very personal, where you breached a contract or you committed fraud or you cheated me or something like that. Partition lawsuit is very basic. It just says, it has basically two parts. One, I'm an owner of real estate. Two, I no longer wish to be. And three, that's it, because there's only two parts, right? It's just A and B. I own this real estate. I don't want to own it anymore. Judge, let me out of jail, effectively, right? So the next step is, in many instances, there's a buyout process provided by statute. that just says, hey, listen, we're going to come up with a value for the property. One person is going to have a right of first refusal to buy the other person out. If they can't afford it, then it's going to go to step 3, which is a sale, which will involve a realtor. And then once the property is sold, it goes to step 4, which is kind of a distribution of the proceeds of the sale, right? So, the word partition, as you probably guessed, comes from the word parts, right? And so it used to be, back in old England, that if 2 brothers inherited dad's farm, dad's 80 acres, and they didn't get along together, they could go to the judge and say, hey, judge, I own this property with my brother. We don't really get along. We're cats and dogs. It's 80 acres. You give me the front 40, give him the back 40. It's all the same. I don't want to be in business with him. And so the judge would say, okay, that sounds fair. Let's cut that property in half. Let's cut that property into parts. Let's partition that real estate. Well, in 2024, and most of us live in, single family detached ranch style houses. And so a judge is not going to, physically divide. He's not going to saw that house in half, right? That's insane. But what a judge will do is sell the whole house and divide the equity into parts. You're partitioning the equity, right? And so in step 4, when the proceeds are divided between the parties, is going to start with basically like a 50-50 split, but also look into, okay, well, who put the down payment? Were there different amounts contributed? Did somebody, maybe the property needed like a sewer upgrade? So who paid for that, right? Maybe somebody paid for a new bathroom, right? And we'll go through that whole part. So when you have this, this pot of gold, so to speak, to be divided, the judge will go through all that, make divisions according to law. And there's a whole bunch of different legal principles involved, but effectively at the end, just say, okay, instead of a pure 50-50, it's actually 57, 43, right? Or whatever the specific numbers happen to be. There are some instances where it can be a true 50-50, but it really just depends on the facts of the case.
So on the case of the boyfriend-girlfriend flavor, my experience is the other party, when they come to me and I'll say, well, the reality is you can force the sale. You have to hire an attorney. There's a petition process. I'm not giving you legal advice, but you might want to go back to your boyfriend and explain to him the facts of law. Nothing ever happens. A high percentage of the time then when they hire the petition attorney like you, before the lawsuit, either a letter sent or a letter with a proposed lawsuit, a filing is sent. And in my experience, the only couple of times we've done that, the other party collapsed. They didn't realize they didn't have the right to hold it forever. They looked at the law and said, wow, I'm really kind of vulnerable here, and move forward. So I imagine part of your business is clients come to you. And again, let's think about specifically the boyfriend, girlfriend, or that kind of individual partnership. Are you involved in that? Or is that an attorney before you? By the time it gets to you, we're now on the litigation freeway?
Yeah, that's interesting. I'll tell you from my experience, and again, I used to do lots of different types of law, right? So I've done, construction defect and easement issues and, neighbor disputes and all these things, right? And so I've written letters in the past, and, generally by the time it gets to me, we're way past the letter writing phase, right? We're way past the talking about it phase, because, you don't need a letter from a lawyer to convince somebody it's real. Sometimes people just say, well, I sent them a link to your website, said, look at this, this is something we can do, and here's who I'm going to hire, or whatever it is. And still they're not persuaded, right? So generally the people who come to me, there's a serious problem to solve. Now that said, so we'll, still try to engage in resolving the issue as quickly as possible with a sale or whatever. So we will file the lawsuit, and then as part of the lawsuit package, we'll include a letter that says, hey, listen, just to let you know, this doesn't have to be contentious. You can, call us, let us know you want to resolve this amicably. We'll work it out. We'll drop the paperwork. But if you don't, you should also know that we're not going to stop until this is sold, right? So it's kind of got the benefit of the letter where you do want to engage the person and say, hey, listen, it doesn't have to be this big fight. But the benefit of a lawsuit versus a letter is there's legal consequences to not responding to a lawsuit. Whereas, a lot of times people will get a letter from a lawyer and they'll just throw it in the trash. And then the client says to me, well, I paid you, a couple $100 to write a letter or whatever it was. What did I get for my money? And
Right.
all I got was more delay. And it sounds like this is a waste of time. And then they're disillusioned with the legal process and with
Right.
lawyers.
Right.
And they say, well, you just took my money and I got this letter and there's nothing to show for it. Whereas a lawsuit, they can't just, if they throw it in the trash, there's consequences, right? The court's
Right.
going to make a decision and proceed. So it puts a clock on things, which I think is helpful because what we're trying to do is actually force engagement. We're saying, hey, listen, we there's this problem. We want to figure this out. But, if you don't want to engage with us, we've got a plan B. And in fact, the clock is already ticking on plan B. So, it would be great if we could work this out, without all the nonsense.
And there's probably not an ending where the property isn't sold one way or the other. I think that's the thing that people don't understand is that at some point you can delay and delay and delay if you're going to spend the money on the lawsuit, but it's going to cost you money to delay. And at the end of the day, you're probably going to lose. I mean, there's really not a solution called you get to hang on to it forever because you're obstinate. That's not in the law, at least. So the challenge there, though, is that boyfriend, girlfriend, to use the first scenario, has to write a check to engage an attorney. The contingency has to at least cover the deposit would have to cover at least the filing costs and to get you to a certain phase. I imagine these are cases where you are estimating the cost up front and taking deposits. It's not on a contingency basis typically, is it?
So we'll do certain cases on contingency. And I think use the term a little bit differently than most lawyers use it. I think most lawyers who use the term, or most people when they think about contingency, they think of like a personal injury attorney who would take like a third or 40% of whatever the value is. So what we do is we'll offer a contingency option. We'll still bill hourly. We'll still show the client all the work that we're doing. And then, from the proceeds, the client will just agree that, we get whatever we've billed, right? And so we just charge a little bit of a higher rate because, we don't lend money for free like the banks
Right.
don't lend money for free. We say, listen, there's a monthly option. We could pay on a monthly basis. If that doesn't work for you, there's an option to pay at the end. We just, the hourly rates are going to be higher. You can do either one. But, we try to work with as many people as possible because we know most people do not have, a pot of money sitting around for a lawsuit. And, we ultimately, at the end of the day, just want to be as helpful as possible to our clients.
Are you able to give the client an estimate of what the final cost will be? Or is that just something, I mean, I know that that's difficult
Sure.
with the law because you never know how hard the other party's going to fight, who they're going to gauge, what kind of nonsense they're going to play. How do you counsel your customers at that point?
Yeah, so it's a really nice question. I think ultimately, when you're talking about an estimate of cost, what you're talking about is like an average, right, or a median,
Right.
and what that is a function of is a function of data. And so I did run the data, I think in 23 for what our costs were. We're going to need to run it in 24. Because, if you're doing, again, 20 different things, you don't really have a sense of what an average cost is because you don't have a data set, right? You've got these different data points and you're comparing pineapples and oranges, right? So, what we do look at is because we just do partitions, we can create a data set from which we can say, okay, we think the cost is probably going to be in this ballpark, right? So I can't say it's going to be an average, but I could say, 10 to 30K or 20 to 40K or something like that, depending on some of the circumstances involved. But at the end of the day, I don't know what the ex-boyfriend's going to do. I don't know if he's, gonna be really reasonable. Okay, now the lawyers are involved. This is not something I want to deal with. Let's just figure this out. Sometimes people dig in, it's, they fight over it and they drag it out and they try to be difficult. We have a number of cases involving, domestic violence, right? These are not the best humans, right? And so, they're prone to fight and they're prone to drag it out, which makes it more expensive. What we what we do try to do for our clients is complete these lawsuits as efficiently and as quickly as possible. And so that's what we do. That is kind of our commitment, is how can we figure this out as quickly as possible. But yeah, as far as the ballpark, 10, 30K, 30 to 40K, something like that. But again, I don't know if, once I serve that lawsuit, the person on the other side of it's going to say, this is way more trouble than it's worth. Let's just sell it, or let me buy her out, or let me engage a family member to help me get a mortgage, or whatever it is. I have no way of knowing that in advance.
But on the flip side, it's not, like I see in divorce cases where there's no end, right? Literally, there's divorce, I'm sure you've seen as well, the divorce cases where it's millions of dollars and running, because it's like a war and they're just grabbing resources and throwing it at each other. To me, it seems like this is a much narrower discussion. They can fight certain things, but at the end of the day, they're either going to buy out you, or there's a court process and you're just getting the judge to decide which it's going to be and then execute that. And I would think that limits the costs at some point in the worst case scenario.
It does. I mean, I think that's, when you're talking about divorce, you're talking about somebody's, entire life, right? You're talking about, what does the retirement account look like? What is the monthly support payments look like? What does child support payments look like? What do we, how does this impact, the house, right? It's a sprawl of issues, right? And I think, as you identified with Partition, we're generally not looking at, well, how much did ex-boyfriend make, and what's his retirement savings, and what's his other property, and did he cheat on her? It's just kind of like, what's the property ownership? What are the contributions? Is there any reason this property shouldn't be sold? And that's it. Now, if we're talking about, maybe the third flavor, as I like to call it, the real estate partnership development flavor, there may be other issues involved with, okay, is this an operating asset, right? Are we talking about, a hotel, and maybe one of the partners was skimming off the top, so you have some theft, right? So you could have other issues involved with that. Is there an LLC that needs to be dissolved? And what else is involved, right? So that's a very different issue. But to go back to the boyfriend girlfriend flavor, I mean, so, one of the issues that could arise is, do we need a domestic violence restraining order, right? So there could be an additional cost there. Does the boyfriend, we're dealing with this in a number of cases right now where the judge has ordered the property to be sold, and the person who's living there refuses to leave or cooperate with the judge. And so we have to do an eviction, right, as part of this, right? So there are other issues that could arise as part of it. But I think you're fundamentally correct, Bill, that it's basically a very narrow problem to resolve.
So let's talk about what you call the second flavor, which is inheritance, which falls most commonly in a probate situation. Mom or dad pass leave a property to two or more siblings. The scenario I see all the time is one of the siblings, like you mentioned, was caregiving, living the property. I think also has lost their ability financially to support themselves in a house like that. So they're used to living there, they're used to living in that kind of a house, and their options are to go off and rent a property that they can't afford because they don't have any real income. They don't want to. They've been used to, nobody wants to make change. They don't have to. And the other siblings are perhaps entitled to life-changing money on their own, whether it be helping their kids, their family, or just paying their bills. I've had literally people on welfare waiting to inherit $500,000 where they can, move into a better care facility to get medical care, for example, as a result. So let's talk about when they discover there's a situation. You now have a probate that's been opened, and there's already been a battle over that between the siblings. And imagine now you're working with a probate attorney, most commonly, that's going to help guide the sibling through and make the decision, hey, we can force your brother, sister to sell. That's what partition action is. That how you get involved most commonly would be through the probate attorney?
Actually, people tend to come to me once the probate process is complete, right? Because probate is just the default process for resolving ownership interests in property following the death of an individual, right? And so, the law may just say, okay, mom and dad died. and they only have 2 kids, right? And so it just goes, they didn't have a will or a trust or anything like that. So because they didn't have a will or trust, it has to go through probate. But now that it's gone through probate, the law just says, okay, to son and daughter. And okay, son and daughter, you now own this property 50-50. Probate has nothing to say about like what happens after that, right? Probate is just resolving the question of what do we do with the stuff that mom and dad owned, right? Including some real estate, right? And so generally where I get involved is somebody comes to me and they say, hey, listen, I've got this order from a judge. I got this probate decision that says, I own mom's house in, Palos Verdes again, right? And, can you help me? Because my sister has stopped returning my phone calls. And I really want to work it out with her, but like, she refuses to discuss the issue. So it's generally following the probate. But also I'll share with you, we have a number of instances where the will or the trust just says to son and daughter 50-50. Right. And so they skip the probate line, right? They skip to the end and they say, hey, I just got this letter from an attorney. It contains a deed and it says I now own, mom and dad's house. But what do I do now? Because, mom and dad didn't take care of the house so great at the end. It needs a roof. It needs new sewer. It needs like some paint. And I don't really want to invest all this money just to have my sister live there, but I also don't want to have a dilapidated property. Maybe I'm getting notices from the city of, nuisance abatement or whatever it is. And I don't really want to invest that money. That doesn't really feel fair. And if I'm not going to get anything out of it, what do I do? Right. So generally it comes to me in those forms following the probate. Because the probate just doesn't address, the use of property once the ownership issues are resolved.
That's fascinating. I can see where a trust would do that. In probate, I've seen attorneys where the property says, split between 2 or 3 siblings and say, well, we'll just divide it, the interest. I say, whoa. You got one living there. You have the luxury now, since you're in probate, of leveraging the inheritance to that sister, right? Because she's going to get, let's say it's $1 million property, she's going to get a third of it. So she gets $300,000. And in your case, a partition action, yes, she might be held accountable for the cost, but in her mind, that's well down the road. In the probate, she's not getting her inheritance until the house is resolved. The judge will hold her accountable for the eviction costs and the partition costs or any delays. And that, to me, I always use that as a hammer to the one beneficiary, if they're not my client, to say, you're going to pay for everything to get yourself out at the end of the day. The judge can take every single penny to the postage stamp to evict you, and that's going to come out of your pocket before you get $1 inheritance. And the other thing is, often these people use probate advances. So rather than wait till the end of the probate, they'll get money along the way. But the probate companies are very concerned when they see that the person's fighting selling the property. And so it's one of those things where I would recommend any attorney or a client who's in probate, don't push this problem until after probate closes. You have leverage. You have a judge you're going to talk to cut the line, so to speak. Obviously, if it's a trust and you get deed the property later, call Elijah and work it out. But if it's in probate, let's talk and see if we can't leverage that to our advantage. So, okay, so then again, that scenario you're talking about is not dissimilar to the boyfriend-girlfriend in that it's siblings, one of them's living there, they need to make a decision what they want to do. In my experience, they kind of tiptoe around a little bit more. They don't have the same poisonous thoughts about their sibling typically they do about the ex-girlfriend or boyfriend. But at the end of the day, it's the same process, right? You're going to file a lawsuit, and either they're going to sell or they're going to have a court process.
Yeah, the fundamental background legal principles are identical. I think, with probate, I think a lot of times, right, people are, they're in grief, right? They're in crisis. Their parent has died. And so they're not necessarily thinking about property, or it's just not on their radar, right? But I think you make a nice point. You can partition property out of probate. Obviously that's a big part of maybe, what you've done in your experience. But it also reminds me, let's go back to the first flavor, so to speak, right? The boyfriend, girlfriend. There's a kind of a subset of that flavor, which actually involves married persons. So we do not practice family law. For the reasons that we've described, we just want to do those things that we do best. But I have had a number of clients who have come to me and said, hey, listen, Eli, bought this house, got married, bought a house with my husband, got, fully divorced, still own the house with him, and got this order, in the dissolution decree says nothing about what to do with the house. It just says, okay, you're divorced, you own it 50-50, good luck. And, so now those people get the pleasure of the privilege of engaging the legal system a second time to sell that property because, kind of like the probate example, the issue was unresolved, right? It was just left out there. And so as a result, the problem needs to be solved. And so that's, we will help people in those instances solve that problem by, finally resolving the real estate piece of it.
Another one I see on some flavor of that flavor is husband and wife, and for whatever reason, one wants to get divorced. They file a divorce. They're separated, but they're not divorced yet, and they own the house. And they're negotiating, and it goes on and on and on. And one say, well, while we're negotiating, I want the house sold. Like, let's take the money and at least split some of it while we argue over the rest. And the other one's just happy to live there for free, in essence, as long as it goes. Is that partition, or is that a family law issue specifically?
Yeah, look, once they're separated, if they're legally married, that's that's in family law, and we refer all those cases out. It's really just a single instance where they, again, they were married, they bought real estate, they got fully divorced, they have a divorce decree, they have a marital separation agreement that's been approved by a judge, and it just says, the house 50-50, and they say, well, what do I do now? Right. In many instances, we'll try to go back to the family court, and they'll say, you're not married, you don't belong here, you got divorced, you can go. And so they have to engage in a partition in that instance. So that's how they'll end up calling us.
So let's talk about it. Now we filed the case, one of the three flavors, and now we're in process. And the court at some point, you mentioned there's two processes. They have a buyout process by statute or a sale. So let's talk about the buyout process by statute. What are the procedures that looks like, and what kind of timetable is that?
Sure. A couple of years ago, the legislature passed something called the Partition of Real Property Act. And the Partition of Real Property Act, it was based on this national movement. It originally began in kind of the southeastern part of the United States, Tennessee, South Carolina, that part of the world. And there was an issue with people inheriting family farms. And those people who inherited family farms, it was generational farms. But over time, people only owned a fractional interest, right? They owned, 1/16 of the family farm, and they were bringing a partition action to have the whole thing sold. And so, there was this idea that that's not the best way to deal with things. There should be a buyout provision. And so this law was, this model law was formed. And it came to California originally as the Partition of Heirs Property Act in 2021. It's now been extended to all property. And so it does have this buyout provision. Basically, there's a couple steps to that. The court will determine the value. It's not necessarily based on an appraisal. It can be, but the court will just make a determination of value, which is kind of an interesting concept. If the court feels like it cannot make a determination of value independently, it can order an appraisal. Once that appraisal comes in, the court can use the appraisal, can disregard the appraisal, and set its own determination. The court is not bound by that determination. And once that appraisal comes in, the court can say, okay, I deem the value of mom and dad's house to be, in Palos Verdes, $2 million, right? And so, sister, you're a 50% owner. Here is, an opportunity to buy this property for $1 million based on the determined value. You have 45 days to make an election. And then from that, you have 60 days to deposit $1 million with the court to facilitate the buyout process. If you're unable to deposit $1 million with the court within 60 days, then we will order the property to be sold. So those, theoretically, that's how it's supposed to go. There's a lot of little wrinkles in that. As you might imagine, selling, family farm or selling a fractional interest in a family farm in Tennessee, kind of different than selling, an operating apartment building in Santa Monica, right? Where there's a lot of other pieces. Was this a good idea? I think it had a lot of good pieces to it, a lot of good concepts. I think that the buyout provision helps to inject some fairness. But I don't think there was sufficient consideration given to, hey, if we have an operating asset, like an apartment building, like a warehouse in downtown Los Angeles, how do these different pieces intersect? And one is just fundamentally not like the others, right? Sure, it works really well if you're talking about mom and dad's house, right? That might not need that much, maybe it needs some repairs, things like that. But you're talking about, again, pineapples and oranges. These are very different asset classes with very different needs. And there's a lot of wrinkles in the law that I think were just created a bunch of unanticipated consequences.
So does one party get offered the chance to bite out? Do both parties get a chance to bid against each other? What is that? Once the court makes a price, how does that offer get worked through?
Sure. So it's kind of interesting. And this is actually something that arises very frequently as a question, is who gets the opportunity to buy out whom? And the law is currently that whoever does not file the partition gets the opportunity to buy out the other. So, which is interesting because people will come to me all the time and they'll say, hey, listen, I own, me and my sister inherited a beach house in Monterey that used to belong to mom. And both of us are very well off, but we just could never stand each other. Right. And so I want to buy it. She wants to buy it. We can't own it together because we can never, we both want the 4th of July. We both want Thanksgiving, whatever it is. And, I've offered to buy her out. She refuses. I don't really want to partition it. I don't want to get rid of it. I just, if I can bid over her, can I do that? And unfortunately, the law does not provide for that. The law, as it currently is written, only permits the non-partitioning property, the defendant, as it were, to have the right of first refusal in the property.
Wow. So theoretically, the court number could be low by the filing party's viewpoint, and now they've ended up allowed the other party to buy it on the cheap. Now, when you mention the deposit, does that work with a conventional type of financing, meaning to put the money into the account? Can I go to Bank of America, get a home mortgage, and have the proceeds paid off, or does it have to be cash or some of the format for the court process?
Yeah, it's an interesting question that arises pretty frequently. I'm going through it in a number of instances right now where there is a I think from the court's perspective is the way the law is written. It just says there's supposed to be a deposit, right? So the process, I think, as you're indicating, doesn't really envision how real estate operates practically, especially real estate in California. Well, but think about it. I don't know. Can you think of some differences between, a family farm in Tennessee and, a property in downtown La Jolla, right? Sure. It's like, well, I don't know. Yeah. I want to sell this property in Tennessee, and maybe the family farm, it's 10 acres and it's worth $100,000 and you have a 10% interest. Well, here's 10 grand. Right. But, if you've got a property in downtown La Jolla, it could be $4.5 million. And so this idea that, well, you just come up with 10 grand and you just deposit it and you don't need a bank, you don't need third parties involved. It doesn't really apply that neatly to California and the way that the world that we live in works. right? And these issues with financing. So the law does not technically address that. Now, what I have seen is, as part of this process, my clients will work with the other ones to, or vice versa, to kind of facilitate the sale. At the end of the day, it's about kind of allowing people to move on with their lives, like being liberated from this bad real estate relationship. So I think there is a lot of cooperation, but not always, and that creates issues.
Well, okay, so and I can imagine there's hard money lenders, maybe that they'll get the money deposited and then they'll refinance the property and get a more conventional loan and lower payment. So I can see there's a whole world of possibilities to get around that. And then obviously, if there's no buyout agreement, the court forces the sale. Now I'm familiar with that process in probate court. I'm also familiar with the sheriff's sale process, but I don't think I've ever seen a court-ordered partition. So are they frequent, and what does that look like?
Yeah, I mean, well, I guess they're very frequent in my world.
Yeah.
So
He said with a big smile.
Well, no, I mean, I love what I do. I mean, and this conversation, Bill, is reminding me of why I got into this process, because I was talking to, to go back to where this conversation started. I was talking to people like you, who's going to real estate meetups, was going to real estate education seminars and learning about, what is a short sale? What is an REO sale? What is a foreclosure sale? Right? Like, how do all of these different types of sales work? And understanding that they all have technical aspects to them, right? There's different steps in the process to manage. Or how does a probate sale work? How does a divorce sale work? Right? There's this whole variety of unconventional real estate sales, and it was part of this process, talking to people like you and just really enjoying the conversations, that I was like, hey, listen, why is no one talking about partitions? Something I was familiar with as an attorney. I said, nobody's talking about this. Obviously following the crash, everybody talked about foreclosure sales and, short sales and REO sales and things like that. But I was like, partitions it's not the same, but it kind of belongs in that universe, so to speak. Right. But to answer your question, and in fact, if you're really interested, on my website, I've gone through and I've said, what is the difference? And I blog post, what is the difference between a foreclosure sale and a partition sale? What is the difference between a divorce sale and a partition sale? What is the difference between, an REO sale and a partition sale? So we actually went through and looked at all the different technical requirements for them. What is the difference between a probate sale and a partition sale, right? So different blog posts kind of detailing the differences, for those who are interested in learning more and educating themselves. So we have information on that on our website, because it was an intellectual curiosity to me. But so at a technical level, and in broad strokes, there is a whole section of the Code of Civil Procedure addressing partition sales. The way they work is the judge orders the property to be sold. Typically, we bring on a realtor to market and sell the property. We try to do it through commercially available means, to try to get the highest price possible, right? Unlike other types of, law, we're not trying to go after anybody, in particular. We're just trying to say, hey, listen, you will get your share. I think, as you alluded to, Bill, sister will get her share in the house, right? And we understand, it's a tough situation, but at the end of the day, she's going to get a pot of money, right? And she will be able to, do different things in her life. But we ultimately want to get the most amount for the property for both parties, right? If we get, $2 million instead of $1.5 million, everybody benefits, including the other side, right? So we try to market and sell it through, commercially available means, through a realtor. Once that, realtor gets, they have to list an end date for when offers are accepted. So they have to say, for example, list on the MLS, this is a sale that's subject to court approval. And we will be taking offers up until August 31st. They have to be submitted in writing by 5 p.m. via email or mail to my office, which is located at XYZ Main Street, right? The realtor will generally determine which offer is best. They have that authority under the Code of Civil Procedure. They'll say, okay, this one is a cash offer, this one is a finance offer, there's different prices. They'll kind of make a determination among the offers of which is the most attractive, make a recommendation to the court. At the end of the day, it's the judge who decides which offer to accept, but the realtor or referee will make the recommendation. The judge will approve the sale, and then from there, it will we'll send it over to escrow and title to go through the normal process to make sure that the buyer is able to obtain and title insurance and process the the transfer as easily as possible. So I know I spoke a lot, but basically
No, it's
those
great.
are kind of the different ideas involved. Yeah.
No, it's great. So, unlike probate, where one offer is selected and brought to court to be confirmed, in this case, all the offers are brought to the judge, maybe with a recommendation, and at that point, the judge makes the decision. So there's no overbid process in court on a partition.
Yeah, it's interesting. So that's correct. There is no overbid process, unlike probate. But I think like probate, generally the referee will they'll say, this is my recommendation. I don't know that, generally they'll say, listen, I received, 10 offers or whatever. This is the one that I think is the best, is the highest and best value for the property. And so they will just generally bring the one to the court, and the judge will inquire. Now there is an opportunity for the other party to object. I've actually gone through a number of trials on this, unfortunately, where the other party says that's not enough money, or I want to do this. And the standard is whether the referee had another offer, the realtor had another offer that was, it's like 10% above the first 10,000 and 5% above that after. So basically, they can challenge whether the another offer was received that was better. But I think I've won all of those trials. Generally it's a very high standard, and the courts are, they're looking after the interest of all parties, but ultimately they see that a lot of times these challenges are raised just to kind of delay the process, delay the inevitable, unfortunately. Yeah.
So probably that happens all the time. I'll give you a statistic. I've tracked probate court confirmation petitions last 5 years, and about 1/4 get approved at court. 3/4 are denied, or half of them are continued due to defects in the petition or the process, because the process is very particular. And at that point, you've already picked one, and so the stakes are a little higher than the judge making the decision at that point. So it is interesting. It's very particular. But I imagine those particularities are done before the offer is accepted, because the judge wants to see it a certain way. So very interesting. So as far as the agent, then, is the petitioning party's attorney then determining what realtor they want to use? It's not the court appointing it. It's not but it's really just relationships with attorneys that we've created value with, hopefully, and they, as a result, choose us to do the business.
Yeah, I mean, so kind of like a divorce sale where, the parties can submit different realtors to the court. Generally it's people who we're familiar with in the industry, who, we think are well qualified, that we'll recommend. But before we do that, from my perspective, I always, look at it from how can I be of service to my client. And so I always start with asking my client, who would you like to use? Is there a realtor who you would like to use? And if they have a preference, I just welcome that. I really try to welcome my clients' involvement as much as possible. And if they, obviously if there's a major problem with that realtor, if they're brand new, this is, their first year in the industry or second year in the industry, I might have to, have a conversation about whether that's a good idea. But, generally, I think as a matter, whenever my clients have requested to use a realtor, we just say yes. A lot of times, however, they don't have a realtor they want to use. And so we'll make a recommendation, or bring in somebody who we feel has good experience, especially somebody who has probate experience. That's something that we'll look for is, hey, you want to do a partition sale. Have you done a probate sale? Have you done a divorce sale? How long have you been in the industry? What kind of education do you have? Right. So these are all factors that we look at to try to make sure at the end of the day, the client's taken care of, and really that's where we're coming from, is just saying, how can I help this client as much as possible? Right. And so we just want to get them the best people. Sometimes the other side will say, we think our realtor's sister or niece or whatever, or neighbor next door is best. And so there's other instances where we'll just say to the court, hey, judge, how about this? We've got this gal, they've got this guy. Why don't you decide? Here are the qualifications, and we'll let you choose. And we'll put it to the judge, and the judge will say, oh, I like, flavor A better than flavor B. And we say that's fine too. But there is no really, I know like the divorce law has a process for that. The partition law does not. But I don't think we're missing anything without it, but it's just not something that's, set forth in the law the way it is in family proceedings.
And I think for those watching this, remember, Eli's working in Los Angeles County, in California, and the laws vary by state and procedures by county, but the principles are the same. And you'll notice he wants to make his customer happy. He'll defer his customer when they can. I imagine if the customer is inheriting a partition property where, they're a modest family, but they inherited some big industrial property, you need an agent that can help with that industrial property, or vice versa. And so it's about, working with customers, working with business people, earning those relationships. And I think the key for all of us is that this is the area we want to get involved with, is do the research in your local market about partition actions. I think there's tremendous opportunity for all of us to learn more, and more importantly, bring value to our customers. So I really appreciate that you brought that. Look, I know we've gone longer. I have a list of other areas. Maybe we can bring it back in another episode. Sure. And go into detail some other parts. But this area, a law that I think affects us deeper than we think. I think that's one of those that affects us when there isn't a lawsuit, by knowing what the outcome could be and helping advise our customers what their options are and to seek proper legal counsel. So Elijah Underwood from Underwood Law Firm. It's Underwood Law, Underwood.law is the website. We'll put that down below. Thank you so much for your time today. I really appreciate the tremendous insight and the experience you shared with us today. Thank you so much.
Hey, Bill, it's a pleasure to be here. And yeah, as I mentioned, I used to, have conversations like this for free in my free time. Obviously there's no money involved here either, but it was just talking about things like this and just loving the field and really loving how, the law can help people get out of these situations. I'll speak all over the state, and I'll do a conference with, 100 realtors. And I'll, kind of give them an introduction to partitions. And people, I always ask at the beginning, hey, who's heard of partitions? And nobody raises their hand. And then, by the time I finish, I'll have, a handful of people who come up to me and say, hey, I've got one of those brother-sister issues going right now. I've got a boyfriend, girlfriend. I've got two friends who invested in an Airbnb property together, and it's gone totally sideways. And I love being able to help people solve these problems and just have these conversations, because I don't know, it just is fascinating to me personally.
Well, again, it's good insight for all of us to understand that when we find something we like and we're good at, we create value for people. It stops being a job and really becomes almost a hobby that we get paid for. So again, separate even for the education, thanks for the motivation and reminder of those important points.
Well, the Lakers were never going to pick me up, so I had to do something.
You and me both, buddy. I was saying, I want to play for the Lakers, but I do the hard work to earn my way in. And so it's one of those things where you better find something you're willing to do every day. So, well, good. Thanks so much. And again, this is Probate Weekly. We do this every week. ProbateWeekly.com. You can sign up online, get reminders, watch prior episodes, watch it on your favorite audio format, ProbateWeekly.com. I'm at Bill Gross Probate on social media, or BillGrossProbate.com if you want all my contact info. As always, make today your best day ever. Thank you, everybody. And again, thanks so much, Elijah. Really appreciate it.
Thanks, Bill. All right, take care.